Let's bring in Tim now to get his perspective on all of this. So, Tim, are you confident that Donald Trump's D.C. trial is going to take place on or around the date that was set today by Judge Chutkan, or could something delay it?
On or around, yes, absolutely. Look, the Federal Speedy Trial Act provides a right for both sides to have a trial within 70 days or up to 6 months thereafter if it's a particularly complex case. It sounds like Judge Chutkan just essentially extended this to the very end of that statutory period, right? The Federal Speedy Trial Act contemplates a trial right away if the defendant or the government wants it and there's no impediment, or at most up to 6 months later. She's applying that standard. It's been clear from the beginning, since the very first proceeding before Judge Chutkan, or even the magistrate judge before Judge Chutkan, that she's determined to move this case along. There's a vital public interest in a speedy resolution. Today, she noted that a lot of the information that will be presented in that case has been public, going back to our hearings or even before with some of the reporting. So, yes, I think it's absolutely clear that barring something really unexpected, that trial is going to happen close in time to the March 4th trial date that she set today.
So to that end, did you get any sense of how Judge Chutkan will handle this case moving forward based on what you saw happen today?
Look, she's a no-nonsense judge. She's very smart, very capable, and very experienced. And I think she's demonstrated that thus far by holding lawyers to timeframes, setting deadlines, expecting briefing, resolving cases quickly. I think she will be resistant to anything that is designed to delay. And I think the other factor that plays into this, Ryan, is that the president's really incendiary public statements that have the potential to impact a jury pool or put parties and witnesses to the case at risk actually are a good argument to hasten trial. The sooner we get this case to trial, the sort of more you're minimizing the potential damage of his pretrial statement. So all of this is contributing to her moving the case very, very quickly.
And one of the arguments that the Trump legal team has made is that they just don't have enough time to go through all the discovery, terabytes of information that they need to go through. But the judge told John Lauro, the Trump attorney, that the grand jury investigation has been public knowledge since last September, that his lawyers should have been reviewing these documents and preparing for this indictment. Does that seem fair, especially since Lauro himself has only been Trump's attorney for a few months?
Yes, absolutely. It's fair. Again, what the judge wants to make sure is that the defendant's team has an adequate opportunity to understand the evidence that will be presented against them. It sounds like the government has already completed discovery, has provided everything and then some that the law requires them to disclose in advance. And the key thing that Judge Chutkan relied upon today is that a lot of those facts have been public knowledge for some time. All of our materials, for example, the Select Committee's information, which really forms the spine of the factual allegations in this case, were made public in very early January. So there isn't a lot in the discovery material, I expect, that is new to the president's defense team.
Speaking of your work on the January 6th Select Committee, let's turn to Georgia now. Mark Meadows took the stand, answering questions that I know your committee and your investigators desperately wanted to ask him and never got that chance. Was it risky for him to take the stand today?
It's certainly rare, Ryan, for a defendant in a criminal case to take the stand in a pretrial hearing. It suggests to me that the Meadows defense team considers this to be a pretty significant and important motion, and they're putting their best case forward on the motion, even if it makes it a little bit more difficult for them at trial. And the line Meadows is trying to draw seems to be, hey, I'm doing all of this in my professional capacity because it's my responsibility to monitor what the president is doing. The problem is that he did a lot more than monitor. He actively participated in the call to Brad Raffensperger, facilitating calls on behalf of the president. It sounds from the reporting about his testimony that he paints himself as this sort of neutral observer, that is, it's in his professional interest to keep track of what the president is doing. The likely response to that is he was actually doing a lot of very affirmative things separate and apart from what monitoring the president that forwarded this intentional scheme to disrupt the joint session. So I think that's what will be the key factual distinction the judge will have to resolve.
And obviously there's a lot to unpack about Mark Meadows' role in all of this, but the specific argument he was making today is that he was acting in his official capacity as a White House chief of staff, and therefore this case should be in federal court Do you think he has a case or an argument to be made in that respect?
Look, he's made the same argument with respect to executive privilege, right? When he refused initially to testify before the grand jury, he said, I'm beyond the reach of this because everything is protected by an executive privilege because I was doing it all in my official capacity. The judge in D.C. disagreed and said there are subject matters that are beyond executive privilege because they were beyond the scope of your responsibility as White House Chief of Staff. It's essentially the same analysis for the judge in Atlanta. The argument by the DA will be a lot of what Mr. Meadows did was not pursuant to his professional responsibilities as Chief of Staff, but was a campaign-type activity that exceeded the sort of job description of his time as Chief of Staff.
And then finally, Meadows, of course, under indictment for his role in trying to overturn the election in Fulton County, but in the federal case, he's still considered to be an unindicted co-conspirator. Does he still risk being charged in that case as well?
Yeah, look, yes, absolutely. The special counsel put forth a very surgical indictment that seems designed to be adjudicated quickly. He did not charge all of the co-conspirators as the DA in Georgia did. He charged the main principal proximate cause of the threat to the joint session. But there are a lot of people that have exposure that may yet be charged or may be thinking about some sort of deal to cooperate in lieu of being charged. Meadows is in that category.
All right, Tim Heaphy, thank you so much. I appreciate it. Unique perspective on all of this, so we're glad to have you today. Thank you so much.
Thank you.
Thanks for watching our YouTube channel. Follow today's top stories and breaking news by downloading the NBC News app.